So as we talked about the creation of international law, one of the sources of international law that I cited was the rulings of international courts and the write-ups that came with that. And so I think it's worth talking about these international courts and the role that they play in helping states coordinate and function and in global governance more broadly. I should flag at this point that we'll be talking about primarily the International Court of Justice and a process of adjudication rather than the International Criminal Court, which we'll hold off for a different conversation. But this idea of adjudication versus criminal prosecution for things like war crimes is really about helping states to resolve their problems. It's an advanced form of conflict resolution where states have disagreements over international law and how it's being carried out and whether they're being harmed by the actions of another state under international law. And adjudication involves handing over the solution to that dispute to a neutral third party. So it's not negotiation. States aren't working together to hammer out their own solution. It's not mediation where a neutral party helps facilitate that process of negotiation. It's handing that problem off to a set of judges who will look at the facts of the case, who will look at international law and come up with a ruling. And so that process of adjudication is increasingly common for dispute resolution around issues of international law. It's not necessarily a new thing. Adjudication under the International Court of Justice dates back to shortly after the Geneva Conventions. The International Court of Justice was rolled into the League of Nations and then into the United Nations system when the United Nations was created. So it has a long history. But now, as part of the United Nations system, there's 15 judges that make up the International Court of Justice, of which 5 are from the permanent 5 members of the Security Council, because international organizations oftentimes reflect the power balances of the international system. But it's not the only source of adjudication. There are regional courts, specifically the European Court of Justice, which oversees disputes between European Union members over whether other countries are fulfilling their obligations under European Union treaties and conventions. And then there's also an adjudication process in the World Trade Organization that allows for member states to bring disputes to the World Trade Organization to be looked at, and the World Trade Organization can rule, yes, this state is violating international trade rules, and you can respond in a particular way. And so both with the European Court of Justice and with the World Trade Organization, by being members of those organizations, you're giving to those courts jurisdiction. With the International Court of Justice, there is an optional statute that gives jurisdiction to the court. And so basically what this means, if you're on this list of, 30 or so countries that have signed this, that if another country brings a dispute to the International Court of Justice, you'll accept that the International Court of Justice has a role to play in resolving that or in hearing that case. If you haven't signed on to this, you can still agree to participate in an International Court of Justice adjudication process, but it's not automatic. You haven't agreed ahead of time with that. And so the International Court of Justice ends up being a really important tool, both in terms of dispute resolution, but also in terms of building up international law. And before I make too big of a case of it, I should probably acknowledge that there's only about 2 cases per year. The International Court of Justice here. So it's not, a massively active organization, and yet it plays this really critical role in helping international law work because it's helping to build up and refine international law, right? So we have international agreements about laying down telegraph cables that are, 150, 200 years old. How do those rules governing telegraph cables apply to fiber optics? Are they the same? Are they different? Those are the kind of things that an international court could potentially help build the foundation for by looking at existing international law and saying, well, here's how it applies now with a slightly different set of facts. Here's what our obligations are under international law as we're interpreting these new situations, right? So that's a really valuable tool. It helps make international law function. It makes it robust and responsive to different situations. Another role of the International Court of Justice is that when states do have disputes, it allows for an off-ramp for crisis, right? Because states can, be encountering an angry public and, inflammatory headlines, and leaders can go and say, we are going to defend our rights under international law. We're going to take this to the International Court of Justice, and we're going to see justice done. And that's a nice response that essentially gets things moved off the headlines and off the front page, and gets a trial date set or a court date set for 6 months down the road, at which point tensions have maybe eased. There's been a chance for back channel diplomacy to kind of work through things, and for states to resolve that dispute before it actually even gets to a full-blown court case. But I think probably the biggest effect of the International Court of Justice is what I'm going to call the unobserved effects. These are the cases that never get to the court, right? So if you are in a dispute with another country over fishing rights, or over territorial waters, or over pollution, or any number of different agreements, you might believe that you're in the right, that you're acting consistent with international law. If a case is filed with the International Court of Justice, your lawyers are going to begin preparing to see, we have to go and defend ourselves and defend our actions, and lawyers will read back through international law and agreements and the context around that, and they may discover, oh, we actually aren't in compliance with international law the way that we thought we were. And if this goes forward to a court case with the International Court of Justice, we're probably going to lose. And so we should be adjusting our behavior and resolving this outside of the International Court of Justice. And so you get that sort of self-correction of lawyers going back, looking at what's the situation and the facts of the law, and realizing that they need to change. So you only really get court cases when both parties genuinely believe that there's a case to be made for them. And that's oftentimes a situation where international law is ambiguous, or it's a kind of a weird orthogonal case that we haven't really seen before. And so when the court does rule on those kind of cases, there's this audience effect as well of other countries around the world look at that and say, oh, wait a second, we had interpreted international law in a particular way, but now we need to kind of rethink that. And so lawyers go back and they look at practice and they look at the law and they realize, oh, we should be adjusting our practice as well, because we had assumed international law when meant one thing, and now maybe it means something else. And so even though there's only 2 cases per year, the role of the International Court of Justice in facilitating cooperation, in getting states to comply with international law, and I guess norming what international law means, is invaluable to the functioning of the international system and the system of international law as a core of global governance.